I'm Clifford, and I want to talk to you today about some of the details of these federal administrative agencies. I've shown how they're completely unconstitutional. They violate the Federalist 47 commitment by Madison that never will any entity within the federal government have all three powers of government. That's why they divided them. We have three branches of government, and there is no fourth branch, which is what these things are. And the Constitution is not allowed to have a fourth branch. The federal government is created and defined in the Constitution. Article 1 sets up the legislative branch. Article 2 sets up the executive branch. Article 3 sets up the judicial branch. And there is no administrative agency branch. And that's what these things are. They are monstrous and hideous things. They are the creation, originally, the guy who came up with the idea of this stuff is Louis XIV. And what it was is, as a child, he and his family had to flee Paris. So they wanted to treat France like a captive enemy who they had defeated in war. That was literally what he wanted for France. So what he did, and previously nobles had their own domain within France. The king really didn't have, the king had much less power than in England, for example. Although the English kings were not allowed to be absolute monarchs, beginning with King John in the 13th century, when the nobles extracted from him what's called Magna Carta, which were, he had to agree that, first of all, their property really was their property, couldn't be taken without due process of law. There had to be a genuine showing of the basis for taking it, and the king could only get it if he paid full fair market value. They had to be paid for their own property. And that's what's true for everyone who owns property in America. We inherited the Magna Carta. It's the unwritten part of our Constitution, because our Constitution was the culmination of the British series of revolutions. You could look at it as one revolution that occurred episodically. Initially in the 13th century with Magna Carta, and then in the 17th century, first with the Civil War from 1640 to 1660. And during the Civil War, it wasn't just about religion at all. People have a lot, there were religious elements of it. And there were some very interesting religious elements. But as King Charles lost his head, he was trying to do what Louis XIV was doing, exerting personal power over the country by having his representatives all over it, so that the local lords no longer were in charge of their own lands. That's what he was trying to do. And that's what Louis XIV did. First, he set up what they were called intendants, individuals. But these were bureaucrats he sent around. That's what these administrative agencies are. They are bureaucracies representing or imposing the power of the federal government, and they each have a specific jurisdiction. Instead of having a jurisdiction like in Louisiana or Kentucky, like in a particular place, it's with respect to a particular business issue, like labor. There are a bunch of agencies which dictate what goes on between employers and employees. And that's a market that should be absolutely free, but it's not. It dictates what employers have to do. It dictates the terms of contracts. And that alone violates the one individual liberty that's in the Constitution as originally written, freedom of contract. Federal government's not allowed to dictate the terms of contracts. And that's what all of those agencies do. And they have the assistance, particularly in the labor arena, the assistance the Wagner Act promotes the creation of labor unions. This is from the New Deal legislation. So it doesn't just permit unions. Unions were not even permitted under the law prior to the Wagner Act. They violate every one of them. The union interferes between employers and employees. Every state has the tort of tortious interference with contract. So they had to override state law to permit unions. But they went further than that. They wanted unions. Unions are collectivist entities, and they basically assist the imposition of central power on the citizens and on businesses. Businesses can't just deal with their employees, and the unions get dues from the employees. These are extracted. An employee joins a business as an employee. If there's a union there, boy, he's in it. He didn't ask to be in it, but he's in it. And The union's claim originally was that they had to get involved representing the workers, that's communist language, against the bourgeois owner, because the bourgeois owner was extracting illicit profits. That's how they view all profit, that it's illicit. They don't recognize that it represents the great benefit that it is, because what happens is the employer who creates or permits the creation of profit by the sale of his goods or services does this because he's providing a service or good that other people want to pay for. These are not stolen from their customers. The customers agree to them. So those are the only relatively free transactions, except they're not, because what's also happened, we have all these agencies, largely the result of the writings of Ralph Nader, believe it or not. Nader's Raiders got all this consumer legislation passed, where the federal government controls the nature of all products. It dictates the terms or every detail of their manufacture, so that it's always going to be the business that creates the product can't just sell the product. They have to have it approved by the government. It's that simple. You ought to see what they do with toys. They look at whether the toy can be mishandled by the child and hurt the child in some one inconceivable thing. Even if the parent wants to buy it, they can't unless the government approves it. And that's true of everything. With cars, you wouldn't believe the number of agencies involved. And by the way, there are about 3 million federal public employees in these agencies. We don't even know how many agencies exactly there are, because some of them are sub-agencies, like the FBI is an agency, but it also answers to the Justice Department. It's part of the Justice Department. So is that one bureaucracy or two? Anyway, what bureaucracy is it's a big group that are dedicated to carrying out the directions from a central body. That's the nature of it. It's a collectivist entity, and they have policies. Now, some of these basic policies are written by Congress, but Congress isn't even allowed to write laws concerning businesses like this. There's nothing in the Constitution that permits it. I've shown that the clause that the Supreme Court relies on exclusively to justify every one of these agencies it's called the Commerce Clause. It's actually the Interstate Commerce Clause, and it has to do with trade, interstate trade, and also trade with foreign nations and with the Indians. So that in order to read it the way the courts have been reading it, Congress would have the power to create laws of policing the activities of individual Indians, which they're not allowed to do, and also foreign citizens. That's how crazy it is. So it's a completely crazy interpretation of the Constitution. They came up with this to justify it. Basically what happened was in the 1930s, Roosevelt passed all this New Deal legislation creating a whole bunch of these agencies, although a whole bunch of them had also been created. And well, the first one was the Interstate Commerce Commission. They're all modeled after that one. They're all virtually identical in terms of their structure. And then in Teddy Roosevelt's administration, he created the FBI, which is a standing army that polices the American citizens. Now, this is completely unconstitutional, absolutely unconstitutional, because it violates everything there's nothing in the Constitution that permits the federal government to police the citizens. There's only 2 crimes the federal government's allowed to prosecute: counterfeiting and piracy, but only on the high seas, so it doesn't need a standing police force to do that. And there was no FBI until Teddy Roosevelt decided to create it to harass businesses. That was its original purpose, and it terrified businesses. It was created in 1906. It caused a panic, and the reality is, as the Supreme Court recognized in Algier v. the State of Louisiana, the English Constitution, which is part of what our founders were fighting to preserve and enforce in the Revolution, it's referred to, although not by name, but its provisions are referred to by name, including the provision of forbidding bureaucrats to harass the American people. It's right in there. And it's in the Bill of Particulars. It's where they're saying what the king was doing that they're fighting against. And bureaucracies, it can be one person, although that's the mentality of the thing. If they don't start out that way, they become that way because they have to get promoted within the agency. Now, the agency writes its own rules. They're called regulations. Rules for us. These would be called laws, but they don't qualify as laws because they're not written by Congress. And the only way these agencies can actually function, because they're giving jurisdiction over a particular part of the economy, the only way they can function is to have all three powers, which involves writing laws and imposing them in orders on the citizens. Now, you have to understand the most basic principle of our government as inherited from the English law is that the only entity that can issue orders to citizens of any kind are courts. And courts can only do it within the common law. There's nothing in the common law that says that the federal government can order automakers to design their cars in a particular way. Nothing. And yet that's what they do. Take a look at all the cars. They all look the same because they all have to comply with the same bureaucratic demands about all sorts of stupid things that are based on nonsense. Nonsense like the idea that we're going to run out of oil. That's from the 1970s. Those rules are still there. That's what requires the mileage demands. The automakers they're called the CAFE rules. Automakers are required to make cars which overall, they're very complicated rules. And there's all sorts of little cute things about it. The reason the SUV exists is because there's two different sets of rules for mileage for cars as opposed to trucks. And what the SUV actually is, it's considered a truck. It's basically a truck chassis with a car built on top of it. And that's how they came up with an SUV. Prior to the CAFE rules, there used to be things like station wagons that were similar, or even minibuses. But now they've got the SUV, but that's the reason it was created, because the automakers are required for their whole fleets of cars to obtain a certain level of mileage for each of the vehicles. And the federal government keeps upping the amount of mileage that is required for cars. So what's happened is, in order to comply with these rules, the automakers have had to change the way the car, not only do they have to comply with all these other rules, they have to comply with the CAFE rules. So there's millions of rules. There's rules from the Department of Safety, Highway Safety. I don't even know all the departments they have to comply with. And by the way, all of the things like seat belts, all the stuff that they're required to put in the car now, airbags, the same number of people die in auto accidents every year. It has remained completely unchanged. It's about 40,000. So it doesn't do anything. All it does is it limits the options for the buyers of what they can have in a car. And it limits the automakers in the kind of design they can have. Little things are required, things like the type of lights. They're not allowed to have certain kind of lights. It's ridiculous. Like if you bring a German model BMW into this country, you can't drive it on the road, even though it's superior in every way to the BMWs that are actually sold here, which are completely different cars. That's true of all the German cars. Although what's going on in Germany now, who knows what's going to happen, because they've destroyed their economy based on the belief in climate catastrophe occurring, which is complete nonsense. And what's happened is the cost of energy in Germany is at least 4 times what it is anywhere else. And that makes it you need a ton of energy in a manufacturing, and that's going to make their cars basically too expensive for the market. And anyway, prior to Trump, those same type of rules were being imposed bit by bit on our automakers. And it would have had the same effect, because all of our power was about to be destroyed. All the coal plants had to shut down. What's happened, hopefully the coal plants that were ordered shut down under these ridiculous regulations that Obama came up with have been declared unconstitutional. So all sorts of things will now change. And the recent Congress, one of the things they did was they eliminated all penalties for not complying with the CAFE standards. So now basically they repealed those without repealing them. So now it's possible for automakers to design cars that we'll really like. Like in the 1970s, they used American cars. Really, they were pretty cool, and they were cheap. They were cheaper than the German cars, and they had more power. Things like Pontiacs and the GM cars and Fords. They had these cars with big engines that had tons of horsepower, and they haven't been allowed to make them because of the mileage stuff. But now they might be able to make them again. Wouldn't that be something? And so basically what Trump is trying to do is get rid of as many of these agencies as possible, and it's wonderful. They control what goes on in every detail of how all businesses operate. And all businesses have to go to these bureaucracies, and some of these, and get their permission. That's what's absolutely forbidden in the Constitution. Our Constitution was written for a nation of businesses. Life, liberty, and property. The pursuit of life, liberty, and the pursuit of happiness, which is what they were fighting for in the Revolution, which is part of our Constitution. Our foundational documents are the Constitution and the Declaration of Independence. So that pursuing happiness meant running a business that you wanted to run with you in charge. And basically, the federal government has taken away the most valuable aspect of ownership, which is making the decisions about the business. And each business is subject to all these different things. There's the Fed that dictates everything about the banking industry, and it monopolized our currency. And it's done a terrible job. It caused the Great Depression. They decide, these depending on who's in it, they have all sorts of personal attitudes, and people. And these are unelected bureaucrats. It was created in 1913. Prior to that, the entire currency was created by private banks, and it was backed by gold. And you could take the currency it's had the name of the bank on the bill. You could take any currency to that bank and trade it in for that amount of gold. And that's the way, and there was never any inflation, and there were never any busts the way there were in the 20th century, all of which were caused by federal government intervention. And what happened in 1929, the Fed decided they didn't like the fact that people were doing all sorts of stock speculation and borrowing a lot of money. And so they pulled the plug, basically, on banks lending money to anybody. It destroyed all of the farms in the Midwest. It destroyed banks in the Midwest. It destroyed banks all over the country. And that was what really caused the Great Depression, as Milton Friedman and Anna Schwartz proved in a book that came out in 1963. This is not debatable. And one of these agencies I'm talking about, which are disgusting, is the SEC. The reason it was created was because one of the big lies that occurred in the Depression was they blamed stock manipulation as the source of the Great Depression. And it wasn't. But that was the basis for creating the SEC. And the SEC controls every aspect of stock and bond, all public issues of securities of any kind. And it controls the whole thing. Broker-dealers, whenever a stock comes up for initial offering, they got to do all sorts of things. They have to write a prospectus and get it approved by the SEC. And it's a real pain in the neck. And that all this does is it imposes additional transaction costs on the company. So lawyers make lots of money from it, and yet what the SEC does, it creates its own laws. It's created its own causes of action, things like insider trading. This is a crazy idea. It's the idea that people who know something about a particular stock or bond, who trade on that insider information, are doing something wrong to the market. Because there isn't any identifiable person who is harmed by this. Now, if they're doing this by misappropriating knowledge of the company as a breach of fiduciary duty, the company whose stock they're trading on based on inside information, it has a cause of action against them. But it doesn't do anything to the market. This is a totally Marxist notion, and it's the sort of nonsense the SEC comes up with. And they have had their own kangaroo courts. And there was a case last year in the Supreme Court, Jarkesy v. SEC, in which the Supreme Court ruled that these kangaroo courts can't impose the penalties that they were imposing. That's what they were doing. They were having they were deciding, well, we're not going to let you go to a real court. We're going to take you to our court, where it's our employees who are on the court. They literally had their own courts. Totally unconstitutional for an Article II agency. That, at most, that's what it is. It's part of the executive branch. Totally unconstitutional for them to have a court. Nothing in the Constitution permits it. And, of course, and when they took people to these courts, they won 99% of the cases. Now, that tells you right there, because nobody goes to trial unless they think they've got a case. And statistically, it's impossible in a fair court for one side always to win, which is what happened in those courts. The Supreme Court finally declared, no, you can't do that. You can't do these private courts. You got to take them to a real court if you're going to take them to any court. Now, the Supreme Court has not ruled that the agency itself is unconstitutional, but that's implicit both in the reasoning of the Jarkesy case and the fact that the Interstate Commerce Clause is what's been used to justify it. And that clause doesn't permit anything like the SEC, which polices businesses. It creates tons of work for lawyers. And by the way, the 5 counties surrounding Washington, D.C., where all these bureaucrats and the lobbyists who deal with them and the lawyers who deal with them, they are the 5 wealthiest counties in the country. And they don't produce anything of value in our economy. All they do is dictate to the businesses who actually do things, who actually create the goods and services that everybody wants. And that tells you what parasitical nonsense having these agencies is. And as I said, they're unconstitutional and they don't do anything of value. And they're horrible. What happens is no individual usually has to deal with more than 1 or 2 of them at most. And most people only encounter the IRS, which is bad enough. These other ones are even worse, believe it or not. The IRS is relatively polite compared to these other ones. They do investigations. They make you turn over whatever they want. They can show up at your house. And they pass these regulations, and violating their regulations is considered a crime, even though Article 1, Section 7 defines all of the Article 1, Section 8 defines all of the crimes that the federal government is allowed to prosecute. As I said, counterfeiting, piracy, but only on the high seas, and of course treason, which was a common law crime, but it's not mentioned in Article 1, Section 8. It's in Article 3, where it limits what counts as treason. They didn't even want the common law crime of treason prosecuted nearly as much as it had been, because they didn't want politicians accusing other politicians of committing treason. And they wanted to limit it to the point that Aaron Burr, who conspired to take half the country away dealing with Mexico and Spain, he had a trial. They had to dismiss it because they couldn't find 2 witnesses. It requires 2 witnesses for treason. Anyway, if you'll notice, the 2 crimes that are permitted for them to prosecute are both commercial crimes. So the idea that the Interstate Commerce Clause just permits any other crime because it involves commerce is nuts. It's literally nuts. And at some point, the Supreme Court's going to recognize that, as it did in the 19th century in the case of Gibbons v. Ogden. Now, I want to also mention the fact that what Congress has done is it's created a situation where we are stuck with a lot of this stuff. We're stuck with the unions. We're stuck with the past legislation and the regulations because the Senate won't repeal it. And the courts so far have been unwilling to say it's unconstitutional. They're frightened. They have to know. They have to know. I can't be the only one in the country who recognizes this. And I've written a brief about it in the Supreme Court. They wouldn't take the case. They didn't want to touch it. I asked them directly to repeal Wickard v. Filburn, which is basically the biggest case on this subject. It's from 1942. And what it is, these things are unconstitutional, and they are horrendous in a republic where we're supposed to be free. We're not supposed to be asking the government for permission to do anything. Oh, the other agency that Teddy Roosevelt set up was the FDA. And under Franklin Roosevelt, there were a whole bunch of these things. But none of them have ever been repealed, even though in 1939, the Treasury Secretary under Franklin Roosevelt testified to the Senate that they were all totally worthless. They didn't achieve any of what they were supposed to achieve. He didn't say it, but the reality is they made the Great Depression worse. They made it last longer because the problem in the Great Depression was unemployment. And nothing makes unemployment worse than for corporations to be under the requirements of all these things. They make hiring employees difficult. And all the labor legislation makes hiring employees difficult. What everybody wants in every market is for both sides of the transaction to be as free as possible to make their choice about what they want. And basically, we've been deprived of freedom of choice in this country, and the businesses have been deprived of their power to run their own business. And the dead hand rule, which is part of the common law, and it's also been recognized as being the case called Winstar, which recognizes that past legislatures and presidents cannot impose their power on the present legislature. But Congress and past presidents have created all sorts of laws, things like the Budget Act, just all sorts of laws that dictate even what legislation the president, Congress is allowed to pass. But the worst thing is the filibuster rule. The filibuster rule essentially prevents the repeal of anything because it requires the majority getting 8 of the minority. That's what it takes. If the majority is 51, they've got to get 60 votes is what it is. 60 votes. That's a supermajority. That means they need a whole bunch of the minority. And that the minority, by definition, have been defeated so that they're the losers. Why do they get to and what this does is it gives the minority a veto on everything. So that basically it becomes impossible to repeal anything. And that's why we're stuck with all this garbage from the past. Worthless, terrible legislation creating all of these agencies. And so far the courts haven't had the guts to say it's unconstitutional. In Gibbons v. Ogden, they made very clear that the justification for these agencies is invalid, that the Interstate Commerce Clause does not permit the creation of anything supposedly to help health or the welfare, anything like that. It doesn't permit it. It's right there in Gibbons v. Ogden. You can read it. And that type of legislation is simply not permitted under the Commerce Clause, and that's been what they have used as their justification, that clause, so that clause is recognized in the one case in the 19th century that dealt directly with this issue. And the Chief Justice, who was one of the founders, expounded on what that clause covers. It's very clear. It doesn't permit any of these agencies. There's other reasons why it clearly doesn't also. There were memoranda written by Jefferson and Hamilton in response to Washington on the constitutionality of the first bank of the United States, which was nothing like the Fed. It was simply a private corporation in which the federal government owned 20% of the stock. And Jefferson said that was totally unconstitutional. It didn't even mention the Commerce Clause. He said there's no way that's constitutional. Hamilton said, well, it's just barely constitutional. But that's the limit of it. So under the present court, we'll see what they do. But what the courts have been waiting for is for it to be the elected branches of government to get rid of these things. The problem is the elected branches of government have been all tied up in having to deal, first of all, with unions and with the filibuster rule, under which the dead hand of the past controls everything now because nothing can be repealed. I'm Cliff Ribner, and I hope you like this video, and if you do, I hope you indicate that and send it to other friends, and visit my website, cliffordribner.com, and read my book, Freedom's Last Stand. Thank you.